Okay, so those are the arguments from the prosecution and the defense. Of course, the prosecution wanting those protesters to be held at bay. They don't want any influence on that jury, that this was a police cover-up, as the defense is suggesting. Let's bring in my two guests to talk about this. I have trial attorney and federal litigator Alexis Rosenberg with me, and also criminal defense attorney, former federal and state prosecutor Kurt Altman. Kurt, I want to start with you. Do you think that the prosecution, the state's concerns that these protesters may influence jurors, is it a valid concern?
Well, I mean, I think it's a valid concern. Clearly, it's a valid concern from their perspective. I just think that the prosecution moving the court to basically intensively restrict a First Amendment right of the public is pretty rare. I think there's a lot of circumstances and a lot of other techniques that the court, in an administrative fashion, can do to protect these jurors from undue influence. Of course, no juror wants to be sequestered, but they have that opportunity and that tool at their disposal. I'm sure that jurors could meet somewhere off-site once they're selected and be bussed in or brought in a van through the back of the Sally Port or whatever in the courthouse. There's a lot of ways for the jurors to avoid these protests without eradicating the protesters.
Yeah, and Alexis, let's talk about that. Yannetti brought up some good points about free speech. And of course, the prosecution has a concern. They want a fair and impartial juror or jury to hear this case. And of course, you see those protesters out there protesting, suggesting it was a police cover-up in this case. But let's talk about the First Amendment. Let's talk about free speech. Do you think that the prosecution is trying to quiet one's ability to exercise free speech under the First Amendment with their argument?
I think that this was a bad strategy move on their part. I think we have real First Amendment issues that we have to take into consideration. And the public does have a right to protest, and they have a right to voice their disdain for something that they think is unjust. So I think taking this position by the prosecution was, in my opinion, a bad move. I think they're going to have a real problem. And now we've got the ACLU jumping in and doing briefs on it. I'm not sure that the defense, I don't know, if I was her, that I would take the Switzerland approach of we're just going to let it unfold. But I think there's a real First Amendment issue here.
Yeah, and maybe not the best optics for the prosecution as they go into this case when the defense is suggesting there was some sort of cover-up by law enforcement. But let's get to the judge's ruling. We heard the arguments from the defense, the prosecution. Let's hear what the judge had to say.
So it's undisputed that under our system of government, the people's right to protest is preserved under the First Amendment, as is the free expression of their views. I have to consider, of course, this very important constitutional right, but the bedrock principle of the trial court is assuring a defendant, it is and it must be assuring the defendant a right to a fair trial, which includes a right to a fair and impartial jury, which by definition is a jury free from any outside influence. So my focus has to be on having this jury hear the evidence and the law and decide this case based solely on the evidence and the law that is heard here in this courtroom. I have to balance the rights of protest. The law is very clear on this. Sometimes these are competing interests. But in balancing them, in weighing all the factors, I do find that an external buffer zone is appropriate and that we do need prudent regulation on in-court expression. But the 500 feet is far too excessive. So I recognize that my obligation is that I must reasonably accommodate the rights of all people to protest in a meaningful way, while ensuring, above all here, that this case is decided fairly based on the evidence without any undue interference from outside pressures or influence in accordance with the law. And that's what I will do.
Okay, there you have the judge's ruling, thinking that 500 feet is far too excessive to keep these protesters at bay. And it looks like the trial has the attention of the public. Kurt, I'm going to go to you. Do you agree with the judge's decision in this case?
Well, I think the judge is in a tough spot, and it sounds like she tried to split the difference and actually impose some restrictions to help keep the trial fair, but also tried to use the very least restrictive means necessary, which I think the law requires. So I think she's in a tough spot. I think she tried to do the best balancing act that she could. And I agree with you what you said earlier about the optics. I think this is very, very bad for the prosecution when they're talking about keeping people away, trying to not let people see things when the theory is that this is a police cover-up. Should be a really interesting case to follow.
No, absolutely. And we're going to be covering it here in Law and Crime when that trial goes. So you can stay tuned here at Law and Crime for that coverage. And Alexis, I want to go to you, just your thoughts on the decision from the judge.
I think it was a good decision. I think that she also laid out the position as to why she made the decision to give that transparency. But once again, it appears, like Kurt said, this probably should have been handled from the admin standpoint and not have to get to this point. Absolutely.
And you can keep it here at Law and Crime for coverage of this trial when it heads to court. For now, we're going to have to take a quick break, but when we come back, more trial news, so stay tuned.